Hello, my name is Sarah Haren and I'm a barrister at Five Stone Buildings, which is a chancery set of chambers in Lincoln's Inn. A lot of what I do is disputes about inheritance and succession to estates of people who have died. And by estates, I mean the property which they owned when they died. And so I'm going to look at a couple of aspects in practice of those succession disputes. I know that the context in which you've been looking at this issue in general is in relation to the family home. As I think Ian has mentioned or will mention, there are really no special rules which apply to the inheritance of a family home, but often in my sorts of case it will be, if not the only asset of the estate, a very important part of it. So what I say goes for the family home as it does for the rest of a person's belongings and property. So, the question really is, if you are the relative or the friend or the dependent of somebody who has died and you don't like what you get, either under their will or under intestacy, what can you do about it? Well, there are two things as a matter of English law that you might think about doing. First of all, if they have left a will, you might consider whether or not there is a challenge to the validity of that will. So whether or not the document which appears to dispose of their assets actually should take effect, because whether it could be said to be invalid on various grounds. And I'll come on to talk about how you might go about challenging a will in a minute. The other major kind of area of litigation in this field is claims under the Inheritance Provision for Family and Dependents Act 1975. And this is a really important statute, which I have to say you may not come across again in the course of your law degree. I certainly didn't come across it until I started in practice, but it's a very important exception in practice to the principle of English law that one is free to leave one's estate to whomever one chooses. And it's the exception to the freedom of testation that applies in English law. It's been around for a while, actually. I mean, although the Act itself is old enough now, it itself was a reenactment of an earlier statutory provision from 1938. So it's fairly well established. It applies where the deceased died domiciled in England and Wales, but not otherwise. So domicile is a concept you may come across in the context of private international law or conflicts of laws. It basically means the place where somebody has made their permanent home, and everybody starts with a domicile of origin, which is, again, simplifying somewhat, where they're born. And you can change that domicile if you move and live somewhere with the intention permanently of staying there and not returning to your original homeland or moving on elsewhere. So particularly it can be an issue where either you've got somebody who was born in England but moves abroad, and there's a question, have they lost their original domicile, or somebody who's come to England from another country, and there's a question whether they've acquired an English domicile. So what the Inheritance Act allows the court to do is to make reasonable financial provision for certain categories of applicant. Not everybody in the world can claim, but as I'll go on to discuss, the categories are fairly broad. The fact you're an eligible applicant doesn't mean your claim is going to succeed, but you must sort of get yourself over that first hurdle of showing you are somebody who falls within the categories of people who can bring a claim under the Act. And so my happy pair at the bottom presumably have had advice that they do have a good claim, or perhaps they've even won in such a claim. Let me go on to the next slide. I'm going to look now at the ways in which you can challenge a will. And there are four main grounds I'm looking at here. And these are the principal grounds in practice that you can say a will is what appears to be a will, what appears to be a valid document actually isn't. The first, and by far the most common in practice, is to say that the testator, the person making the will, did not have the necessary mental ability, mental capacity to understand the things which are necessary to make a will. Now, long established case law says the things that you need to be able to understand are basically three. One is what does making a will mean? What is the nature of a will? In other words, you need to be able to understand that it's a document that disposes of your property after you die, that you can revoke it during your lifetime, but otherwise it will govern what happens on your death. The next thing you need to be able to understand is the size and nature of your estate. So in broad terms, whether or not you're simply dealing with your family home or whether you have millions in the bank. And the final thing you need to be able to understand is who might expect to be provided for from your estate, who might reasonably expect to be provided for, sometimes described as the claims on your bounty, but for whom might you reasonably be expected to provide? You need to be able to understand that to evaluate, what will you should make. It's the most common ground of challenge, really, because the longer people live, the more likely it is that their mental capacity will have declined somewhat from where they were in their prime. But really important to remember that just because somebody has a diagnosis of dementia or has some form of impaired capacity does not necessarily mean that they have lost testamentary capacity. So there was a recent challenge to capacity against a former judicial member of the House of Lords called Lord Templeman, and he had obviously been a brilliant lawyer in his day, but his capacity had undoubtedly diminished when he came to make his last will. But that will was nonetheless held to be valid because his decline in capacity was not so much as to rob him of the things that he needed to be able to understand to make a valid will. The next ground of challenge is very popular with clients, but it's very difficult to bring home. I mean, often people come and ask for advice about this, and the advice is quite frequently, well, you just don't have enough evidence. And that's a challenge on the grounds of undue influence, whether improper pressure has been brought to bear on the will maker. And it's difficult to bring home in practice because you actually positively have to prove that the will was the product of that improper pressure. And whilst you can do that by circumstantial evidence and showing that there was a relationship of bullying or coercion or otherwise the will maker was under the thumb of somebody, it's really quite rare for there to be enough evidence that a court will accept that a will was not the free choice of the will maker. Thirdly, you might say that the will wasn't properly executed. And you may know that in English law, under the Wills Act 1837, there are particular formality requirements for making a valid will. And those are that the will maker must sign or acknowledge his signature in the presence of two witnesses, and those witnesses must themselves sign or acknowledge their signatures in the presence of the testator. Interestingly, under the coronavirus pandemic legislation, there has been an amendment to the Wills Act to allow video witnessing, because obviously with social distancing, it was sometimes difficult to achieve the necessary formalities in person. So that's a kind of novel development and obviously a welcome one, although some of the formalities required for video witnessing are themselves sufficiently complicated. I fear that they're likely to give rise to work for me in the future. The final ground of challenge is a slightly obscure term, which is lack of knowledge or want of knowledge and approval. And I think it's not just lay people who don't always understand what that means. It's, as I say, not a very transparent terminology. But what I think it really means is that the will maker didn't sufficiently understand the contents of their will, so that it didn't reflect what they wanted to do. And in practice, examples of where that might be the case are if the will was really drawn up at the instigation or instructions of a third party, and the third party sort of put it under the nose of the person making the will, and the will maker didn't read it through properly and didn't really know what it contained. It can often be an issue where the testator, the will maker, doesn't have English as their first language, but the will is in English, and then there might be a question whether or not these provisions of the will actually reflect what the testator wanted. But in practice, if you can show a link between what the will maker has said, what they want to happen, and the contents of the will, it should be easy enough to show knowledge and approval. And in practice, I think there's a real judicial reluctance to uphold challenges to wills, because after all, the person who could give the best evidence about the making of the will is dead, and furthermore, they're not going to have another chance to make a new will. So I think there's a sort of judicial keenness to discourage unmeritorious will challenges, and to live with wills which, might in some ways be slightly questionable. So that's challenges to wills. The other area of litigation in my field is about claims under the 75 Act. And your client might be in the position of Oliver Twist, asking for some more, or indeed something at all, because often your client will have not received any provision under the will or the intestacy. So what's the scheme of the Act? I mean, I mentioned before you've got to fall within certain categories of applicant, and who are they? The applicants are limited to the following people: spouses or civil partners of the deceased. Former spouses or former civil partners can sometimes make a claim, although nowadays on a divorce, it's very often the case that there's a clean break and they're disentitled from claiming. Children, and this is where people can sometimes be surprised, because adult children can make a claim. They're eligible to claim as much as minor children, although their claims may be less likely to succeed for reasons I'll come on to. Really, really important category in practice, I touched on, I think, before, which is cohabitants, people who are partners, living with the deceased as husband or wife or civil partner, but not actually married or in a civil partnership with them. They've got to be living in the same household for 2 years before the deceased's death. And because the intestacy rules don't make any provision for such people, this can be their only really remedy or right of redress if they are left without provision on the person's death. And there's also interesting contrast, because if you break up with somebody during your lifetime, under English law, there's no way of making a sort of claim for palimony or provision of that sort if you're not married. But if they die, you do potentially have a claim under the Act. So there's a sort of slight mismatch there in how the law treats partners or cohabitants in those situations. And the other big category of claimant is dependents, people who are being maintained either in whole or in part by the deceased immediately before their death. And that maintenance could include the provision of accommodation, as well as, or instead of, actual sort of handing out of money. What's the test? Well, the test is, as I've said, what's reasonable financial provision in all the circumstances of the case for the applicant to receive? Has such provision been made on death? And if not, well, what is it the court should do? There's a distinction to be drawn between civil partners and spouses on the one hand, and all other categories of applicant on the other. Spouses and civil partners are not limited in their claim to what is reasonable for them to receive for their maintenance, but everyone else is. So everyone else, the court can only give them what is reasonable in all circumstances for them to receive for maintenance, and that means discharging their costs of living. It's not a way of making sort of fair or large capital distributions. They may well get a lump sum of money, but that lump sum of money is there to meet their recurring costs of living over whatever period the court thinks fit. Spouses and civil partners are in a different situation because the court there is not limited to providing for their maintenance. And the reason really is because Parliament didn't want to disadvantage spouses and civil partners on death compared to their position on divorce. Because on divorce, court's not just looking at maintenance provision, it's also looking at what it will be a fair share of marital assets for the divorcing spouses. And in a large estate, at least large enough estate, you would not expect a spouse or civil partner to come out worse on death than they would on divorce. So what factors does the court take into account in deciding what's reasonable financial provision? Well, I've mentioned the divorce comparator for spouses and civil partners. But for all claims, really importantly, the court's looking at the financial resources and needs of both the applicants or applicant and the beneficiaries. The court's looking at the obligations that the deceased owed to make provision, the moral obligations the deceased owed to beneficiaries and to the applicant. Looking at any health factors that might be relevant, so any mental or physical disabilities which the applicant or beneficiaries might be suffering. Obviously, it's got to look at what's in the estate and what its size is. And also the court has regard to conduct, although it's only relevant conduct which comes into play. And in practice, it's pretty rare to have such bad conduct that an otherwise kind of good claim would be defeated. And what's the court award? Well, again, I hope I'm not repeating myself too much, but the court is making an award of reasonable financial provision in all the circumstances of the case. It's going to be limited to an award of maintenance in the case of anyone other than a spouse or civil partner. And so it's not redistributing just because it thinks it's fair to do so. It's meeting a particular need in the case of anyone other than the spouse or civil partner. It's meeting a particular maintenance need of that applicant. Now, need is a necessary criterion. You must show that you have that need if you are an applicant other than the spouse or civil partner, but you've also got to show that there's a good reason why it's the deceased that ought to be meeting that need. And that's why you look at things like the obligations, the relationship, the size of the estate, and so on. So a case which really is an interesting demonstration of how the Act works in practice is the Supreme Court decision in Eilert and Mitson. And it's the only case under the 75 Act to reach the Supreme Court, the highest court in the land. So it's kind of very exciting from that perspective. A colleague of mine in Chambers, two colleagues of mine in Chambers represented the charity defendants in the Supreme Court appeal. And so it's really a central decision both to my practice and to this area of law. It was a claim by an adult child, Heather Eilert, who had been estranged from her mother, the deceased, for a good 26 years. Mother had disapproved of her choice of husband. So the deceased left her estate by will, fairly modest estate, under £500,000, to some animal charities. Heather Eilert brought a claim under the 75 Act for reasonable financial provision from her mother's estate because although her marriage was very happy and they'd had several children, her husband was not a high earner and she was on benefits. She was a full-time mother and she led an extremely modest lifestyle. She hadn't had a holiday for years, hadn't been able to buy fridge, freezer, television. She was renting a council house and her rent was being met by housing benefit. So it gave rise to some really interesting principal questions, like what difference did it make that she was estranged from her mother and had no expectation of inheritance? Should the award relieve the state from the liability to maintain Heather as it was by paying her benefits? I mean, what was the interrelation between her benefits entitlement and any award that was made? The Court of Appeal, in one of the many appeals in this case, had given Heather Eilert a sufficient sum to buy her council house outright. And there was a question whether that was really a maintenance award at all. So there were those three sort of really big questions of principle. But what's also really interesting about this case is that it was clearly one that could have been decided in any one of a number of ways. The district judge, at the first time round, gave Mrs. Eilert £50,000. Something, but not a lot. This triggered a whole spate of appeals. First of all, there were two appeals as to whether or not Mrs. Eilert should get anything at all. The Court of Appeal said she should. And then there were three appeals about how much she should get. And that was ultimately what the Supreme Court was looking at, how much she should get. Because the Court of Appeal, as I mentioned, gave her enough to buy her house on appeal. But the Supreme Court overturned that and reinstated the original district judge's award. What's actually fascinating about it, though, was Baroness Hale's judgment, which said, here is a case where the district judge could have reached one of three possible conclusions. He could have said, on the basis of their absence of any relationship, it was reasonable to give her nothing at all. Secondly, that the Court of Appeal's decision, was a possible outcome that the district judge could have reached, give her enough to buy her house, or what he actually did, somewhere in the middle, give her a sum of money which would allow her to meet some of the costs that she needed to meet, like to buy new appliances, to go on holiday, which would sort of help her meet her, improve her lifestyle. So it just shows the width of discretion that the court has under the Act. As for the points of principle, it said that, yes, the estrangement was relevant. It was a factor which pointed towards a sort of lower end award, because although Mrs. Eilert was in need, need by itself is not enough. You have to look at all the circumstances, and the nature of their relationship and the absence of any expectation of inheritance was a pointer against a very, very large award. The next factor was the relationship with benefits. And the Supreme Court didn't say a huge amount about this, but it's interesting that it justified the initial award on the basis it wouldn't actually interfere very much with her benefits entitlement, because she could use it, as I've said, to buy some things in the short term, and then she'd revert to being on benefits, but her lifestyle would have improved. And then the final point is that the Supreme Court did suggest that actually in normal circumstances it would not be a maintenance award to give somebody a house outright. That hasn't necessarily stuck as well as some of the other things that the Supreme Court has said, because not making an award of a house outright can give rise to some horrible practical problems. It's often easier to have a clean break between family or quasi-family members. But it's a really interesting case, as I've said, in showing how the outcomes can change according to which judge is deciding the case. Problems that arise in practice and misconceptions about the Act. Well, what the Act isn't about is defendants often feel, when faced with a claim under the Act, that it's just not fair. It's just not what she would have wanted. It's not, this giving her anything was completely anathema. It was not at all what the will maker would have wanted. That's just not the test, though, because almost by definition, if somebody has made a will and they've expressly excluded an applicant from provision, the testator may well have decided, as Mrs. Eilert's mother had decided, not to make provision for her, but nonetheless the court has to apply the objective test, the objective question, the criteria under the Act, whether or not reasonable financial provision has been made. Sort of from a claimant's perspective, the kind of reverse misconception is that the court can interfere just because the provision is somehow objectively unfair. Again, that's not correct. It's a necessary precondition of any claim, at least of spouses or civil partners, that there is a maintenance need for the applicant to have a good claim. And if an applicant has enough resources or a means of supporting themselves, their claim doesn't get off the ground, even if it's not fair that the testator has left them with nothing. And equally, unless you can challenge the validity of the will, it's not good enough to say, well, the will operates or the intestacy operates in a way that wasn't expected. For example, a beneficiary is now much better off than she was at the time that the will was made, and now, you know, it's all not working quite how the will maker expected it to. That's not a ground for interfering under the 75 Act. So more pitfalls in practice. Well, as you might expect, there's a time limit for bringing these claims, and that's 6 months from the grant of probate or letters of administration. That's the grant is when the court makes a formal order, you can start administering the estate. So that kind of puts a time limit on when claims can be brought. Time can be extended by the court, but it puts pressure on people to get on with it and bring their claim if they're going to. As I mentioned at the outset, it only applies to people who die domiciled in England and Wales. So you've got a problem if your testator or your deceased person is domiciled outside the jurisdiction. You don't have a claim under the 75 Act then. You might have to think about, you know, the laws where they did die domiciled to see whether you've got any redress. And a real practical problem is the case of small estates. So let's say your estate is just the family home, and you've got a partner, minor children, a spouse, and, you know, dependent great aunt. There may just not be enough to go around, in which case the court has got to prioritise whose claim is the strongest, who has the most call on the deceased for provision, who is in the greatest need, and may have to cut out those who otherwise would, in a larger estate, have had a good claim. So those are the sorts of practical problems that these claims can throw up, but it's a really interesting area of law, full of human interest stories and some really difficult and knotty legal problems too. So I would encourage you to, you know, keep this area of practice in mind, particularly if you're ever interested in going to the bar. Have a look at maybe doing a mini pupillage at Five Stone Buildings or another traditional chancery set, because it's, you know, it's got a lot to offer as an area of law. And so enjoy the rest of your introduction to law and your law degree, and bear this in mind. Thank you very much.